Good morning. The first case to come before the court this morning is Sandra White versus Bureau of Workers' Comp and Quest Diagnostics. Both sides will have 15 minutes in which to argue their case. The appellant may reserve 5 minutes for rebuttal. If you're the appellant, you wish to reserve that time, let me know when you come to the podium. I'm keeping track of the clock and I'll keep you apprised of the passage of time. We are being visually and audibly recorded to be posted online, so please try to remain behind the podium as much as possible. We have read your briefs and ready to proceed when you are. It's my understanding that the appellants versus Workers' Comp and Quest Diagnostics, you understand that you're splitting time and you agreed to how much time each of you is going to have.
We have, Your Honor. Tim Marcovi for Quest Diagnostics. Ms. Thomas and I have discussed it, and I will be arguing on behalf of the appealing side today.
Okay. Thank you. All right, we're ready to proceed when you are then.
Thank you, Your Honor. Good morning. May it please the court. Again, I'm Tim Marcovi. I'm counsel for Quest Diagnostics, Inc. At this time, I'd like to request 3 minutes for rebuttal, if I may. Thank you, Your Honors. Your Honors, there's a simple, specific question presented by this case. That question is, when Sandra White fell in that part of a parking lot that a contractor was in the midst of repairing, when she was out on a walk, on her unpaid lunch hour, on a path of her own choosing, performing an activity of her own choosing, which had absolutely no connection to her job as a data entry clerk, did she sustain an injury compensable under the Workers' Compensation Act? As a matter of law, Your Honors, the answer to that question is no. The trial court's decision, therefore, to the contrary, must be reversed, and under Appellate Rule 12, this court, which reviews this matter, which come to you on summary judgment, reviews them de novo, enter the judgment that the trial court should have entered, which is granting Quest and the administrator's motions for summary judgment, finding that no compensable injury was incurred. Revised Code 4120-301C defines an injury, an industrial injury covered by the industrial accident insurance as those that occur both in the course of employment and arise out of employment. Course of employment, the definition is whether the injury occurred considering the time, the place, and the circumstances of the injury. Arising out of the employment is whether there's a sufficient causal connection between the injury and the employment. That depends on, according to the Supreme Court, the totality of the circumstances, although the Supreme Court has identified 3 factors. The proximity of the scene of the accident to the place of employment, the degree of control the employer had over the scene of the accident, and the benefit the employer received from the injured employee's presence at the scene of the accident. The cases are all very fact-specific, Your Honors, but they do provide guidance, and that guidance leads ineluctably to the conclusion that this was not a compensable injury. Here, it wasn't in the course of employment. Let's look at the factors of time, place, and circumstances. Time, she was off the clock. She wasn't being paid. She was doing what she wanted to do on her unpaid lunch hour. Place, she was nowhere near where her work was done, nor, Your Honors, was she anywhere near anything incidental to her work.
Well, counsel, what's in the record about exactly where she fell?
Your Honor, what's in the record about where she fell is in her deposition. I think if you look at I think it's page 36 of the deposition. Actually, it starts on page 35 and it goes over. She fell in a portion of the parking lot off the sidewalk outside of the building that was at the time being repaid by a contractor. She testified in her deposition that the contractor had begun work several days before, had stopped because the final step, the putting the asphalt on, they had run out of asphalt and were waiting for delivery of a new supply of asphalt.
Is there something in the record that indicates the cause of the fall?
I believe it's her testimony is that the uneven nature of the portion of the parking lot that she was walking on.
Because the brief seemed, one of the briefs seemed to indicate something about stepping off a curb. But I won't belabor that point. Let me ask you this hypothetical. Let's say she had, it was her lunch hour and she was walking down the hallway of the building to visit a family member in the library. The carpet was being replaced in the hallway. She tripped and fell in the hallway.
I think that would be dependent on a couple of things, Your Honor. First, it would be dependent upon, well, let me answer your question directly. First of all, I don't think that would be in the course or arising out of her employment. She's on her lunch hour, it's unpaid. That portion of the building in which she is walking is under the control of someone else, a contractor who's doing some work. And she's doing nothing that is connected to or incidental to her work.
Even if Quest contracted with a contractor to do the work?
I think that puts it in the control of the contractor. This Exhibit A that's alluded to in the briefs, the work proposal, not even a contract, as you'll notice, Your Honor's Exhibit A wasn't signed, but the proposal of what the work is to be done, if you look at the first page of that, Your Honor, you'll see that there's specifications, what work is being done. And the very first specification is mill as needed for proper construction. Anybody who's driven during road repair season in Ohio knows what that means. That's the part where they bring in the machines and they scrape off the old asphalt, preparatory to putting the new layer of asphalt on. That's what milling is needed for proper construction, and it's right there. I can't imagine how the owner of the parking lot or the carpet or the roadway would be able to control what's going on when the contractor is removing the old asphalt. This is completely divorced from any control. And it's different, Your Honor, than many of the cases cited by the appellee, where, for example, there's a slip and fall on ice. There, it's simple. The owner of the property can send an employee out to throw a bucket of rock salt on the ice. There's no equivalent here. So clearly, the control was not in Quest over the area, the unpaid or broken up area, in the process of being repaid, that on which Ms. White tripped.
So in this case, the court, it sounds like the court held that ownership of the parking lot equated to some sort of control, applying the liberal construction that the law requires of the workers' comp statute in favor of an injured party. Is that a fair assessment?
I think that's what happened. The trial court wasn't clear on that, but the way I took it was, yes, they were equating ownership with control, which, again, is simply not the law. There are a myriad of circumstances where one can own real property and not control it. If it's leased, if you give someone a license to do something, as I think the contract here is clearly a license to the contractor to do the repair, over the control over the property to do the repair work. But ownership can't be conflated with control. And Judge Teodosi, as far as liberal construction is concerned, let me just address that point for a second. Liberal construction of the law is in 412395. There are cases, and we've cited them, liberal construction of the facts is not covered by 412395. That's first. And I believe that what the trial court did was misapply the liberal construction rubric to apply to the facts here, not to the law. They're moving on to the arising out of point, and again, talking about liberal construction.
But it's liberal construction of the statute, I think, is
Yes.
the law.
Yeah. But one of the points here is a benefit to the employer by Ms. White being where she was when she was at the time she fell. There is nothing in the record that supports the slightest benefit to the employer of her being there at that time. The fact that she was walking is really something that falls under, I believe it was the Williams and Martin Marietta case, that the benefit to the employer, the benefit the employer derives from the activity has to be a substantial direct benefit that extends beyond the intangible value of the employee's health or moral improvement, which is common to every kind of recreational and social event. That's what her taking a walk was. It was nothing beneficial to the employer.
Now, I know she was covered under her husband's health insurance.
Correct.
Was there any other Quest company policy where they had a benefit for physical activities?
There was a wellness program that she wasn't participating in. She testified to that at page 43 of her deposition. She was doing the activities, she wasn't participating in the program.
Counsel, I'm going to change the scenario in the hallway. So her lunch hour's coming up, and she called and ordered some food from a delivery service. She clocks out, she walks down the hallway, there's nothing wrong with the carpet. She's on the way to the lobby to pick up her lunch food. That's all we know, and she falls. Of course, it's scope of the employment, or no?
There's no contractor fixing the carpet. I would say in that case, Your Honor, we would not be here because my client would be paying benefits.
Even though she clocked out for lunch?
That is a factor. It is a very important factor. It is not always a determinative factor. But in this case, in our case, Ms. White not only had clocked out, but was doing an activity on her own, away from her job, and not doing anything incidental to her job. And by that I mean, Your Honors, she wasn't doing any comfort break. She wasn't going to the bathroom. She wasn't doing anything with economic benefit. She wasn't going to HR to pick up a paycheck. She wasn't going, well, in the old days, it used to be going to the smoking area to get a cigarette. Nobody does that anymore, but those are what the cases are talking about. She wasn't doing any of those things. She was simply engaging in a personal activity, very, very similar to the activity that the plaintiff in Tamarkin case that this court decided there's simply no benefit to the employer and no control the employer had over the activity at the time. This case is on all fours with Tamarkin. Finally, Your Honors, a couple of other things that liberal construction won't do. There's an assertion that the Supreme Court, when it talked about the totality of the circumstances test, said that the list of 3 factors, none of which are present here, is not exhaustive. But nobody's identified another or different factor, not the plaintiff nor the trial court. There simply isn't another factor shown in the record in this case. So to allude to other factors that can make up the totality of the circumstances that's simply a red herring in this case, because no one's identified one. Another thing that liberal...
You're just at 3 minutes.
20 more seconds. Another thing liberal construction won't do, Your Honors, is it won't change the wording of the statute. If the trial court's decision is affirmed, it changes this from an industrial accident statute to a general health insurance statute. That's something for the legislature. Your Honors, the trial court erred. I'm asking this court under Appellate Rule 12 to enter the order that the trial court should have entered, denying the plaintiff's motion for summary judgment and granting the 2 defendants' motions for summary judgment. Thank you, Your Honors.
Good morning, Your Honors. May it please the court, my name is Patrick Morrow, counsel for Appellate and Ms. Sandra White. Your Honors, I request that this court issue an order affirming the trial court's order granting motion for summary judgment in favor of Appellate Ms. White for 3 primary reasons. First, based upon the facts at hand, it is clear that Ms. White did suffer an injury in the course of her employment. Furthermore, it is clear that Ms. White did suffer an injury that arose from her employment with Appellant Quest. And furthermore, in consideration of these factors, it is important to keep in mind, as this issue has already been touched upon, that these considerations must be liberally construed in favor of the claimant in this situation, Ms. White. I think that there's a couple overarching themes in the appellant's argument that require consideration. First, appellants prescribe an extremely narrow view of what constitutes arising from employment. That is, if they could have it their way, it would be one can only suffer an injury. In the case of Miss White, for example, who was a data entry clerk for Quest, she can only suffer a compensable injury while she was performing her tasks as a data entry clerk.
He just stated if she's walking down to get a check from HR, that would be compensable.
That would be compensable.
It's not
But
sitting at her desk typing, though.
correct, but throughout throughout these proceedings, that has been the primary driver by the appellants. They are prescribing and, in my opinion, trying to assert a very, very narrow interpretation of what would be considered in the course of and arising out of her employment. The law is clear that there's a broader zone of employment when it comes to employing, or in terms of employees and the actions that they take in the course of their everyday workday. And to that end, some of the points that were raised there, that Miss White what she was doing was completely divorced from her employment, is simply not true. She did testify in her deposition. It was in that same page 35 through 36. That she had a regular practice of taking this walk every day. The employer was aware of it, and furthermore, the employer never had an issue with it. She went on this walk primarily because she had a short lunch break of 30 minutes and didn't give her enough time to leave the premises and come back.
Counsel, in your estimation of it, does it matter the proximity to the building where she fell?
Absolutely, yeah.
So had she fallen on the other side of the parking lot while she was taking this walk?
Had that been the case, would it be compensable?
Correct.
Absolutely, because it would still be the employer's premises. And we have determined throughout these proceedings that Quest is the owner of the property where this took place.
Also then, do you agree that the record's clear where she fell? And
Absolutely.
why she fell?
Absolutely. Ms. White did testify in her deposition that the reason she fell, she was walking out of the primary employee's entrance that she always used as a means of ingress and egress from the building, walking on the sidewalk, and as she was stepping down from the sidewalk step onto the unpaved surface, that surface was unlevel, which caused her to fall and fracture her wrist.
Unlevel due to the construction that was occurring?
Correct. Yeah. One of the considerations that we went through at great length, particularly in the trial court, is basically the entire parking lot had been repaved except for the portion essentially abutting the sidewalk. So there was basically no way that you could avoid this hazard that was created.
Could she have used a different exit of the building to get to her walk?
There was, regardless of which way she went in, she would still have had to encounter this unsafe condition.
So every exit had the same situation?
Correct. Correct, Your Honor.
And that's in the transcript?
Correct. Yeah, that is in the transcript. And furthermore to that end, she used the same entrance every single day. There's been this assertion that she willfully chose her path of how she should get in and out of the building. That's simply not true. I mean, she testified that how she get in is how she got in, and so on and so forth.
And the construction of the parking lot had been going on for some time?
That is my
So
understanding.
there had been machinery out there all this time? This is daylight?
This is daylight, correct. And this condition, as I said, was basically there was no way but to go through it. Furthermore, Ms. White did testify that there was no safety alert that this condition was unsafe. There were no cones, there was no red tape, there was nothing. Simply the employer, invited their employees to go across this unsafe condition. And that kind of takes me to my other point with respect to control, because I think that that's a very major issue in this. We spent a considerable amount of time contemplating the Lord factors, which essentially boil down to three things: proximity, control, and benefit to the employer. In my opinion, there's without a doubt that the proximity in this case clearly weighs in Ms. White's favor. So does the issue of control. I simply do not buy the argument that by hiring a subcontractor to come on to your premises somehow relinquishes your control over the unsafe condition or the area that was affected by it. I guess by way of analogy, if I were to hire somebody to come onto my property and repave my driveway, for example, and rips it up, and in the process, before they replace that, someone comes onto my property and is injured by this now unsafe condition, I would still be held responsible for it. I would certainly have a right to go after the contractor for whatever reason, that they failed to protect from this unreasonably safe condition. But that does not resolve or absolve them from any liability with respect to the issue of control. It's your property, you own it, you have control over it. Furthermore, in this case, they're the general contractor. They hired the paving company to come onto their premises to repair this pavement. They were in the course of doing so. You're ultimately liable and under control of that premises.
So is the analysis of control exactly the same as it would be in a liability analysis on a civil suit?
I think it's very similar. However, we're kind of in this different, we're kind of in a different land in terms of workers' comp, which, creates some complicating factors from that end.
Well, the standard is different, isn't it? It's not whether the employer was at fault or negligent. It's a different standard. It's whether or not we've talked about that.
Right, and that you are correct. But I guess to my point at the end of the day, regardless, that you own the property, you have control over it, ultimate control over it. They could have fired the contractor. They could have hired another contractor to come in and finish the job for whatever reason if they were behind.
So is that the argument that ownership equals control?
Yes, I would say that by owning that property, they're in total control of it. Lastly, there was the issue of benefit to the employer. Essentially, they're making the argument that there was absolutely no benefit to Ms. White's, her activity at the time of her injury. I disagree with that. I think that they certainly have a benefit to Ms. White being on the premises during her lunch hour, simply because she's on the premises. If she were ever to be needed, she's right there. She's not going anywhere.
She's off the clock.
She is off the clock, but just because you're off the clock and your employer tells you to go do something, I think you would probably go do it. I guess at least from her perspective.
She's out in the parking lot, because she does this every day, right? So she's out walking every day, is what you said.
Correct.
So she spends her half hour off the clock time in close proximity to her employer, but not.
She's correct. She's not right at her desk, but I presume that if they were to ever need her, that would certainly not be an issue. Furthermore, I think they do get a benefit in the sense that she performs a very I guess dedicated job in the sense she's constantly entering data all day long. I believe that having the opportunity to have your employee take a quick break, get a fresh air, certainly helps her be a more effective employee, especially when she's performing such a task that requires constant attention to entering correct data. I think that at the end of the day, I really do think that this comes down to a consideration of the issue of control. Proximity, as we have discussed, she's certainly on the premises, hasn't even made it essentially to the parking lot before she fell. And that injury did occur on their premises. Furthermore, I think it goes without saying that they certainly had control over the premises as well. While the trial court found that there was only a tangential benefit to the employer by having her out there. You know, I would certainly assert that to say that the employer had no benefit at all, I simply don't agree with that. I think that there is a benefit to the employer. But to that end, I have nothing further. Thank you.
Attorney Markova, you have about just over 2 minutes.
I'll try to use less than that. Thank you. A couple of points very briefly that counsel for the appellee raised that I think need clarification. The first is if you look at the deposition transcript from pages 34 through 36, what you'll find out is that Ms. White testified that the only reason she was out there was to take a walk, get some exercise. It was sunny, it was beautiful. There were actually 3 entrances. I'm quoting now from her testimony. And question, it was pretty much your choice which one to use. Answer, yes. And getting to that point, the point at which you tripped, you chose the pathway. Answer, yes. So as far as what the facts of this case are, the undisputed facts, I might add, that's the fact of the matter. Secondly, the police said it comes down to control over the property, and he equates control with ownership. This court's prior precedents completely belie that. Let me quote to the court from Tamarkin versus Wheeler. Wheeler's accident occurred technically at his place of employment. The circumstance must be tempered by the fact, however, that his duties as a baker's apprentice did not require him to be in the parking lot during working hours. The mere happenstance that an employee was injured on his employer's property without more is not sufficient to warrant benefits. The issues that were raised by counsel for the appellee regarding who had, whether or not in the tort law system, Quest might have been held liable. Judge Teodosi, you're absolutely correct. That's a negligence law analysis which doesn't have anything to do with workers' comp law in this instance. What has to do is who had control over that piece of ground upon which she was walking when she tripped, and who had control by her own testimony and by the exhibits in the case was the contractor who had ripped off the old service and was in the process of applying the new service. With respect to the benefit to the employer, availability. Availability is what he said. Well, she could have gone to the lunchroom and sat down and opened up a book and read it, and she would have been even more available. Your Honors, all of the facts militate against granting compensation in this case. We'd ask that the trial court order be reversed and the orders of the Industrial Commission reinstated, finding that she is not entitled to participate in benefits. Thank you, Your Honor.
Thank you both for presentations today. The court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as closer to our website. Thank you very much.